Yeah, I hear you, everyone.
Can we start now? Can we start? Okay, excellent. Okay. Good morning good afternoon or good morning, depending in which part of the world you are listening to us in this moment. My name is Luca Belli. I'm professor of Internet Regulation and Internet Governance at the Fundação Getulio Vargas FGV Law School, and I have the pleasure to be one of the organizers of this first CPDP LatAm session at CPDP. Together with me today, there will be many of the members of the advisory board of CPDP LatAm that are playing a key role in shaping this initiative and also in shaping this session and the debate today. We have the pleasure and honor to be to have with us today Professor Danilo Donella, who is professor of the Brazilian Institute for Public Law and also a member of the board of the newly created Privacy and Data Protection Council, which is an advisory board of the newly created also Brazilian Data Protection Authority that is today represented here by Miriam Wimmer, one of the directors of the new authority. Then we will have Professor Pablo Palazzi, who is director of the Center for Technology and Society at Universidad de San Andrés and also partner at Allende Brea. Then we will have Anna Draper, who manages the Information Society program of the OSF, the Open Society Foundations. Then we will be joined in some minutes by Renato Monteiro, who is Data Protection Council lead for LatAm at Twitter and also the founder of Data Privacy Brazil. And last but of course not least, we will have Catiza Rodriguez, who is Policy Director for Global Privacy at the Electronic Frontier Foundation, the EFF. Now, the reason why we have convened in this panel today is that there have been major developments in the Latin American region over the past years, and they are not very well understood, or they do not have the visibility they deserve. And so we have decided to create this new initiative, CPDP LatAm, and this new platform for discussion and better understanding of data protection and privacy in Latin America. Just to provide you a couple of very brief examples, in Brazil, a country of 210 million individuals, there is a new data protection law since a couple of months in force. A new data protection authority, as you have heard, has been just created, is in the process of being created. Argentina will have a new data protection bill that is now in the process of being discussed. Many countries are now struggling with how to cope with techno solutions to COVID-19 and contact tracing, and how to make it compatible with data protection concerns. And this is just a little bit of appetizers to start our conversation today. Now, without further ado, I would like to ask Professor Danilo Donella to start providing just a little bit of context on the latest update in Brazil, so that then we can start with our opening remarks by Miriam Wimmer. Danilo, the floor is yours.
Very much, Luca. I'm very happy to be here as part of the CPDP LatAm event, which will hopefully happen this year after the cancellation last year. I'm very happy to be in a panel with so many friends in a moment where when data protection in Latin America finally comes out as a very important and strategic issue. I'll be very brief just to introduce some points that might be touched by our speakers, but just remember, Brazil 10 years ago had a very early and still immature discussion on data protection. And right now, Brazil is the country with the most people living under a data protection legislation. The 210 million people living in Brazil makes of the country the biggest population under a general data protection legislation. And of course, the size, the structure of data protection can be shaped by countries such as Brazil entering the global dialogue with questions such as international data transfer, which were primarily oriented by necessities and conceptions in some regional blocks, but now expand to begin to form part of a global transnational dialogue, which have to take into considerations particularities of many more countries. It's a part of a global dialogue, much more than the standards imposed or drafted by a specific group of people. And I must also stress that Brazil has a very particular situation regarding data protection, in the sense that LGPD, which is the General Data Protection Law, which entered into force last year in Brazil, it was not only claimed by Brazilian population, Brazilian citizens are so worried about their personal privacy. We can see this in newspaper almost every day, that there are matters of concern to the people, but also institutions, enterprises in Brazil pressed in order to have the legislation, in order to have legal certainty, security on the use of data. Just taking as an example, the recent cases regarding the use of personal data because of COVID launched some problems in Brazil when in the first phases of the pandemic, some institutions were asked to produce data, and they were not comfortable with this, even for public interest purposes, because Brazil lacked a general regulation which could bring security and could make those organizations more comfortable with the data sharing, even in the sense they would not be sued afterwards. So Brazil position is very new. I understand that now ANPD Director Miriam Wiener, which we are very honored to have here among all the other friends who are here, Pablo Palácio, Catícia Rodrigues, Renato. I'm going to enter in more detail about this. Thank you very much, Luca. I return the word to you.
Thank you very much, Danilo. And it is indeed extremely important to have now a new general data protection regulation in force in Brazil, not only to enforce, to let individuals enjoy their rights and enforce those rights, but also to create juridical stability for businesses and public institutions that process personal data, exactly as businesses may do. Miriam, now you are the star of our today's discussion, because everyone wants to know what is the new data protection authority doing, how is it going to be created. So please, the floor is yours, and thank you very much for being with us today.
Thank you very much, Luca and Danilo, for these kind introductory words. It's a great honor for me to participate in this important debate, along with so many other distinguished speakers. I'm truly honored by the invitation, and I apologize in advance. I offer my deepest apologies because I unfortunately will not be able to stay until the end, but I realize that Renato will be joining us shortly and will certainly have many interesting things to share on the situation in Brazil. So Luca asked me to provide some context on the recent developments here in the country. So I'd like to offer some information and also provide some perspective on what the main challenges are moving forward. And as Danilo very correctly mentioned, the debate on data protection here in Brazil has been going on for approximately 10 years. Danilo was in fact one of the most important authors of the first proposals for Brazilian legislation on this topic. And after a very complex and lengthy political process, our law was approved finally in 2018. It did not enter into force immediately. There was initially a grace period of 18 months, which was then extended to 2 years. And the idea was that during this period, there would be time for businesses and organizations to become compliant with the new legislation, and also for our national DPA to be created. However, in Brazil, there's always a plot twist, and when 2020 arrived, the DPA had not yet been created, and we also had to face the pandemic. And so pressure increased to once more postpone the entry into force of the law. But finally, after lengthy negotiations, the National Congress decided to not further postpone the entry into force, and the law actually became effective as of September 18th, 2020. Immediately afterwards, there was a presidential decree issued in order to create our National Data Protection Authority, our ANPD. And shortly afterwards, the 5 directors were appointed, examined by Senate, and they finally took office on November 6th. So this is all very recent history that I'm sharing here. ANPD was actually created less than 3 months ago. And now that the directors have been appointed and that work has begun, we have a number of important challenges to face, which I'd like to share briefly with you. I'd say, speaking in general terms, we have the challenge of building a robust data protection environment in the country that provides for good and simple rules for businesses to comply with, while retaining a high level of data protection for individuals. And this is certainly not easy because Brazil does not have a long-standing tradition of data protection. And also, quite similarly to what happened in Europe when GDPR entered into force, there is always an initial reaction of shock and panic at having to deal with a new and complicated legislation. This is particularly true for smaller businesses. So I'd say that one of the main challenges we have before us at this point is raising awareness, education, capacity building, which implies, of course, a more profound cultural change in the way we deal with data and the importance we attribute to data in our modern digital economy. In this sense, an important development here in Brazil was a recent decision issued by our Supreme Court in the context of data sharing for statistical purposes during the pandemic, in which the Supreme Court recognized the existence of fundamental rights related to personal data protection, autonomous fundamental rights derived directly from our Constitution. So this is certainly an important point, an important inflection point in our domestic debate on personal data protection. Here in Brazil, we also have an important challenge related to our enforcement scenario. As many people have stated already, before the approval of LGPD, we had a very fragmented landscape with several sectoral laws, with rules applicable to specific fields, for example, telecommunications, the financial sector, for health purposes, and also horizontal laws such as the Consumer Defense Code, which applies to all sectors of the economy. And now we have the LGPD, which aims to provide a common approach towards handling data and respecting data subjects' rights in different economic sectors and also in the public sector. But we still have an important challenge in terms of the fragmentation of our enforcement landscape. In Brazil, we have many different organizations with enforcement responsibilities. So we have, for instance, a highly developed consumer protection system with over 900 local bodies responsible for this. We also have a very active public prosecution system with prosecutors who act independently throughout the country. And finally, in Brazil, it's very easy to file a lawsuit. So there is also a challenge related to avoiding mass litigation. In this sense, perhaps one of the most important roles that ANPD has to play from now on is that of interpreting our legislation in order to provide a common understanding of the rules and to create more legal certainty for implementing the law. We are currently working on approving our regulatory plans, our regulatory agenda, so to provide clarity as to which issues we plan to tackle in the short term. And we are also initiating discussions with other public bodies with responsibilities in the field of consumer protection and also regulatory agencies. Another point that was already addressed by Danilo and by Luca is the issue of cross-border data flows. And this is, of course, a priority in our increasingly digital and globalized economy. Our legislation has a portfolio of mechanisms quite similar to the GDPR. So we have the possibility of transferring data based on consent, but also on standard contractual clauses, adequacy decisions, binding corporate rules, certification mechanisms. So now we have before us the task of developing and detailing this portfolio of mechanisms in order to allow us to competitively include our businesses in these global cross-border data flows. Finally, the last issue I'd like to highlight very quickly refers to the structure of our national DPA. In fact, this is a very exciting period because we are creating something from the ground up, from zero, but it's also a very demanding task. So we are facing tasks such as finding a physical location for our offices, hiring staff, preparing websites, and concluding our internal rules of procedure. It's actually a very hands-on job at this moment. And we're also working hard to constitute our multi-stakeholder advisory board, which was mentioned previously, which is composed by 23 members representing different sectors of government, of the judiciary, of Congress, of civil society, labor organizations, academia, and also the business community. But I think perhaps our main challenge lies with making ANPD actually become an independent and an effective regulator. We have a provisional legal nature, so we are currently connected to the executive body, to the direct administration, to the presidency of the Republic, and this is of course not an ideal scenario in terms of independence. So I'd say that our main challenge is perhaps over the next 2 years, in fact, working towards changing our legal nature in order to ensure full independence and transparency in decision-making processes, as well as ensuring an adequate and predictable budget. So I think these are perhaps the most important tasks that are before us at this point. I hope this information is useful, and thank you once again, Luca and Danilo, for the kind invitation to provide this context on what is happening in Brazil.
Thank you very much, Miriam, for this very sharp presentation of the most pressing challenges in the current situation. It's indeed a Herculean task to create from scratch a new authority with such overarching remit and with such important role for 210 million individuals and thousands of businesses. Now, the situation has also been evolving quite interestingly, not only in Brazil. We will come back to Brazil with Renato, and particularly also with analyzing cross-border data flows that Miriam already mentioned, an issue very interesting and a key issue at the moment. But now let's try to move to another Latin American extremely relevant country, Argentina, with not only relevant for size of the population and for dimensions, but also because it has been one of the first countries to adopt a data protection law in the early 2000s, and now is in the process of updating it. So, Pablo, thank you very much for being here with us today. You are probably one of the most experienced data protection lawyers of your country, not only teaching, but also practicing the data protection law since more than a decade, I think almost 2 decades. So thank you very much for being with us today, Pablo, and please, the floor is yours.
Okay, thank you, Luca, and thank you to CPDP LatAm for the invitation to be part of this panel. So what can I tell you about Argentina? We started 20 years ago with a bill. The bill was approved in the year 2000, so the bill is 20 years old, and the DPA was created 1 year later by a decree. It started with some challenges. As Miriam Wimmer was explaining, the DPA has also to find a place within the administration, to find an office, to find people. So initially they were in the Ministry of Justice, and then they moved to an office that they obtained from the money laundering office in Argentina, and they used that premises. They started only with 5 people. Now they are like around 50 people, I think. And they have an issue with the first challenge that the DPA has was to become autonomous. As you know, the idea of independence of DPAs is very important for a European model. And that happened only a few years ago when the government enacted the Transparency Law or Freedom of Information Act that created an independent authority. So the government took the DPA and put it under the transparency government, and it only became independent 4 years ago, and autonomous. Before that, it was a national directorate under the Ministry of Justice. Our law, as you know, is based on the 1995 European Directive, so it's kind of old in terms of internet law. And there's discussions in government to update the bill with a GDPR-style legislation. There was a bill that was introduced by the DPA after a long discussion of academia, NGOs, and companies, but the bill was not addressed by Congress, so it fell out. And now there's a new bill that is going to be discussed by government and the opposition, which is based on GDPR also. And so going back to what happened in these 20 years, you can separate two levels: the activities of the DPA itself and case law in Argentina. No, as you know, in Argentina, it's very easy to litigate. It's very easy to file an habeas data, which is an action to enforce the Data Protection Act. So there are a lot of cases against credit reporting companies, against banks, against hospitals. There's also a lot of cases related to damages. People are claiming damages for data breaches, for wrong information, etc. There are a couple of class actions, which is the new frontier in data protection. The reason for this is that because data protection sometimes for an individual is a very small infringement, so it doesn't make sense for an individual to file a litigation only of himself. But class actions are coming to the Argentine scenario, and there are a couple of class actions related to data breaches and to infringement of data protection law. On the administrative side, the DPA has been very active at the beginning with two things. First, registration. It forced every company in Argentina to register its database at the DPA. As you know, registration is something old nowadays, so the bill will take out that duty from companies. It will not be mandatory to register a database. The second avenue for the DPA was to do enforcement through first audits. They will go to a company or a bank, an insurance company, and ask them to provide a long list of questions, and they will go through every aspect of the law with that company, and after that they will decide whether to issue a certificate of compliance or to open an investigation for some infringements. And with respect to infringement, the DPA was very busy, and now you can take into account the last cases of fines for the Do Not Call registry, which is it's a section of the Data Protection Act that protects unsolicited calls for marketing, and the fines there are very big. They are very big for Argentine times, which is around 3 million pesos, which is $20,000. The rest of the fines, for example, there are a couple of fines for data breaches, one against the federal police, one against Yahoo, the US company. And those fines, because they don't apply the Do Not Call registry law, they are a bit lower in terms of fines. But they also mandate companies to adopt measures to protect personal data. There has only been cases against Uber, Google, Facebook. In terms of international data transfer, Argentina has a growing and very healthy evolution from a very strong protection and non-transfer rules to a lot of options. Nowadays in Argentina, you can use standard contractual clauses that were approved by the DPA and which are based in the European standard contractual clauses. You can use international data transfer agreements without using the standard model. You can use consent. You can use binding corporate rules, which the DPA has regulated and has approved a couple of companies, which is BCR, usually European companies. There's also something very important, which is the fact that if you look at the regulation of the DPA in the last 4 years, I would say that the DPA has been issued regulations to comply with GDPR requirements, which are not in the law. So actually, you can say that Argentina has a DPO obligation for the government, which is not in the law, has a binding corporate rule regulation, which is not in the law. It has a data protection impact assessment regulation issued together with the Data Protection Agency of Uruguay. They did a joint work, and they issued this in collaboration, this joint regulation, which is very important because nowadays everything is global, so it's important to have these global regulations. And looking at the whole, you can conclude that Argentina, even though doesn't have a GDPR style regulation, the whole set of regulations that were approved by the DPA will comply with a GDPR analysis of adequacy in case we need to do it. And of course, we all expect to have a new bill approved at the end of the year, so we are GDPR compliant. And in terms of collaboration of the DPA with other DPAs, there's this case of the Uruguayan collaboration I already mentioned, and there's another case of investigation of a company which is Argentinian but was hosted in the UK, and the DPA tried to collaborate with a UK agency to enforce these rights of Argentine citizens. So, and of course, you know that Mr. Bertoni, who was the director of the DPA until a couple of weeks ago, has quit the DPA, so the DPA is vacant at this time. We don't have a director, we don't have a public official in charge, but we all expect the government to cover that position with someone who has expertise and has practice in data protection. So that's the state of art in Argentina. I'm open if you want to send me questions or to discuss any concrete matter. Thank you very much.
Thank you very much, Pablo. I'm sure that there will be questions in the last segment on the question and answers, and very interesting to see how the Argentinian DPA has completed and updated the Argentinian framework based on the existing law, but building on it some GDPR-like norms, some regulations that have brought up to date the Argentinian framework. Also very interesting to see the cooperation that happened with Uruguay. I think that could be a very good practice, maybe an example of best practices to be analyzed at the regional level to foster more cooperation between data protection authorities in Latin America. Now, let's move to another important issue that we are. First of all, let me welcome. I see Renato Leite. He has entered the room, and very welcome amongst us, Renato. Before giving the floor to Renato, I would like to go back to our other very pressing item of the day, which is COVID-19 related measures. That is a theme that has interested, well, of course, the entire Latin America, but the entire world over the past months. We have actually issued a call for papers that had the emergency tackling and the compatibility of these measures with data protection as one of its main topics. And we have just released this morning the first of the publications that we will release in the upcoming weeks, that are a result of these very well received call for papers that receives 107 submissions. We now have the pleasure to have with us Hannah Draper, that has a very special approach to this, as she is not only an expert in these issues and how technology is fostered to limit, it is used to foster or limit fundamental rights, but also she has a very interesting approach because she is a funder of many of the initiatives that analyze this and also create interesting solutions to this, not to mention that she is also one of the members of the advisory board of CPDP LatAm. Thank you, Hannah, for being with us. Please, the floor is yours.
Thank you so much, Luca, and also parabéns on the welcome reception for your call for proposals and the tremendous response that you got. So thank you also CPDP and especially the tech folks who've been amazing. And yes, of course, fellow panelists, it's really nice to see you all in one place again after too long. So I'm really happy to be here today. I'm a program officer at the Open Society Foundations in the information program. And over the last 7 years or so, I have been working to support a field of actors to protect and advance digital rights. And I've had the pleasure of being able to spend a lot of my time in Latin America, working with different actors there. And I wanted to talk to you about some of the leading approaches that I see coming from the region, and like really sophisticated thinking that I think that other parts of the world could really benefit from considering. So thanks for that. And great, thank you. Next slide, please. Great. So the latest public security crisis, the COVID-19 pandemic, which this time has affected the whole world, has, like many other public security crises before it, fostered a renewed interest in extending surveillance infrastructure, both policy and the physical infrastructure itself. I think in the past, we've seen narratives of terrorism, migration, trafficking, etc. And I think in a public health context, it's even easier for the public to get on board with mechanisms that invade their rights because they can understand that it's for a greater public interest result. So, I mean, there's no doubt that different technological approaches certainly can scale, reach broader audiences at speed. They have tremendous data collection capacity and analytical capacity, but there seems to be a myth that infotech, or as I like to call it in this context, techno solutions, are sort of a magic bullet or you know, an instant resolution to complex social, economic, and political problems. So I wanted to talk a little bit about why that isn't the case, and in doing so, reference some of the work that I think is particularly extraordinary coming out of the Latin American region. So first, if you have an app or a website or any other sort of techno solution, you have to make sure that the data inputs are correct. So we are talking a lot these days about legal identity, which is not the same as digital identity, but there are a number of identity concerns for different communities within Latin American populations. So you would have to make sure data inputs about individuals, you know, are consistent and minimal, etc. But really, I think what's most concerning is techno solutions such as contact tracing apps or immunity passports. They're relying on assumptions that aren't really useful. For example, if you have a COVID test and you input the results of your test into the app, and then that app can be used to grant you access to shopping spaces, workspaces, travel, and just like the public sphere generally, this is a problem, because I'm currently here in London in the UK, and in this country, we're seeing that 24% of COVID tests, according to the UK government information, are inaccurate. I couldn't find statistics for other places, but even with this awareness, you know, the results of COVID tests with false negatives and false positives are being used to determine whether or not somebody can access public spaces. And of course, as soon as you come into contact with somebody else, your COVID status could change. And similarly with vaccinations, unfortunately, vaccinations are not available for everyone in the world. We see countries like Israel and Canada buying up to 5 times more than necessary for their global populations. And I recently saw, I believe Colombia is only expected to first get vaccines in February, late February. And of course, not everyone can have vaccines, and they are not always 100% effective if they are administered correctly. Again, shout out to the UK government, a joint committee of politicians with, I'm not sure their medical background or training, took a decision that the Pfizer 2-dose vaccine could be administered on a timeline differently than was advised. So we don't know yet how Latin American administrations will deliver and offer vaccinations because they don't have strong access yet. But here, due to manufacturing, lack of manufacturing capacity, it will be some time now before second doses are available, meaning that those with their first dose have to go back to 0 and start again. Of course, there's also asymptomatic carriers, etc. So another major concern that I have about these techno solutions is function creep. So we can see data sets being combined. We can see informal proposals being developed about this. We see that sometimes it's just happening without, public debate or the opportunity for scrutiny. And of course, the collection of all of these data sets is great for these public-private partnerships because they offer more insights into social behavior and control, etc. I just wanted to also flag, I'm spending a little bit too much time on this slide, but I want to say security is another major vulnerability that we have seen many problems with. And data leaks, depending on the context, you can face a range of challenges. It could be, commercial exploitation like ID fraud, or you can also see individuals who are enemies of other sectors or factions being targeted. And then just really quickly, a lot of these techno solutions, of course, are based on the assumption that you have access to internet. But again, going back to Colombia for a second, I believe 20 million Colombians live in places where they do not have access to internet. Actually, I should say residents of Colombia. So if we want techno solutions to work, they need to be developed on thoughtful, multidisciplinary research. And I think that we can't ignore how important social trust is to get people to share what is actually needed to put in the inputs into apps that are required. And sorry, I'm having trouble changing the slide. I was wondering if I could get some help. Thanks so much. So I just wanted to highlight some of the work that I think is really extraordinary coming out of the region, that as a funder working globally, I haven't seen other examples quite as strong as these. Of course, I'm not able to see everything all the time, but I do think that these approaches from Charisma in Colombia, Internet Lab in Brazil, and Derechos Digitales based in Chile, but working regionally, they're really demonstrating how to think critically about these approaches and make sure that infotech that can be easily exported from the minority world, the richer industrialized countries that sort of take for granted, rule of law and access to resources and infrastructure, etc. Those don't always fit. If you don't have internet connectivity, for example. Okay, so thank you. And I can have my next slide, please. Thanks a lot. Okay, so when is surveillance okay? this is an excerpt from a blog post that was written by Paulina Gutierrez. She is on the advisory board of Indela. Well, I put the website there, indela.fund, but Indela, which I'm very happy to be able to work with her on. And she is also working at Article 19. And I've put her Twitter username there too. So Paulina, in the excerpt from this post that she made, and you can find it on the Indela website to read more. So she sets out, governments do have a responsibility to the public interest of their populations, but in doing so, they need to make sure that the data that they're using is necessary and proportionate and being used for a legitimate purpose, because otherwise we see a lot of risk to, well, not just privacy, but equality, enfranchisement, freedom of expression, self-determination, freedom of movement, et cetera, et cetera, et cetera. Next slide, please. Thanks so much. So in my work, I've funding digital rights. It usually means funding work on policy advocacy and litigation and the use of other legal mechanisms from time to time. So I think I may have skipped a slide, but that's fine. I don't know. Okay, let's do this one. Great, thanks. So I wanted to say that, thank you. So the collection of personal data, of course, we do have the right to privacy, and the Inter-American Convention of Human Rights sets out our privacy rights. However, Section 27, which is looking at when those rights are not guaranteed, and that could be perhaps in a state of emergency, which we've seen in many places around the world this year, including in Latin America, where many countries are adopting or have adopted a state of emergency for the first time. They're really grappling with what are acceptable limitations on personal data and privacy and other rights as well in an emergency context. So I am really excited about emerging work from Alsur. The website is there, alsur.lat, L-A-T. And this project I really like because, excuse me, so I flagged 2 organizations there, both of whom are members of Alsur, which is a consortium of 11 leading digital rights advocates in Latin America from more or less across the region. And Cele and R3D in particular have, given a lot of thought behind this project, but others as well. It's just that I've already spoken about them on other slides. So what is acceptable limitations to our rights in emergency context? And first of all, that's one question on its own. But secondly, when our rights are affected by infotech or digital technologies, that requires an additional understanding of the implications. And of course, infotech is constantly evolving. So, sorry, I'm getting a bit of feedback. It's constantly evolving. So it's difficult for duty bearers and to keep up to date, and policymakers, the public, etc., everyone, even the private sector developing such technologies. So I'm excited for this body of work in particular because they are monitoring from across the region together all of the policy developments. Like you look to Brazil, and it's basically been a DDoS attack of policies impugning rights, usually through a technical mechanism. Actually, Data Privacy Brazil, Renato will speak more about their work shortly, but they've developed a really interesting project on techno-authoritarianism, looking at all of this. Okay, So monitoring the legislative developments, then analyzing them and making recommendations for how they could be more protective of rights, but also meet the intended objective. And I think this is really important for us to be thinking about. You know, there's been many reasons for social unrest in the Latin American region, while from time in perpetuity, but you know, in late 2019, we saw the uprisings in the Andes in particular. Brazil is often in the streets, and I mean, the women's rights movements, yes, it's been spectacular. But now with the global recession, I'm worried about increased social unrest, because there will be a lot more poverty and job loss, and yet at the same time, we have these emergency measures which have permitted increased limitations on our privacy. Okay, excuse me for being distracted there for a second. So may I please now
sorry if I interrupt you, Hannah. Yeah, I just wanted to ask to wrap up, because yes, sorry. Thank you very much.
No, thank you, and I apologize. I got a little distracted there. So the last slide, I just want to touch on capacity building. I just wanted to say one of the biggest takeaways that I have had from 2020 is that law and policy is super important, but if you don't have sorry, do you mind going to the capacity building slide, or else I'm gonna, thank you. I just don't want to lose my way. Okay, so once we have judicial personnel and journalists and academics, and also like empowered and informed consumers and public that are more aware of their rights, I think that, like Miriam was saying, it's a lot easier to establish, you know, changes in culture, and as Pablo was saying, you know, improved meaningfulness in enforcement. So I've got some examples there of different projects that were going on. I would love to talk more about them. I've provided my contact information on the last slide, but some really interesting work in Brazil and in Paraguay from TEDIC, the Clínica Jurídica, where really building in awareness of rights. I'm done. I'm sorry, Luca. From an early pedagogical moment, I guess. Okay, and then this is just the information about Al Sur. I see, sorry, it's become out of order, but I kind of just have the last one. Thank you very much. Super. So thank you so much for the opportunity to speak here, and for inviting me, Luca, and sorry for going over. And if you want to find me on Twitter, I can send you all these resources.
Thank you very much, Hannah, for your excellent work, and also for highlighting that techno solutions that are typically fast-tracked by governments, usually with reduced parliamentary scrutiny, frequently outlast the emergencies and may create more problems than what they are aimed at solving. And also stressing a very common point that I think links all presentations, the need to build a data protection culture and to let people understand the value of data protection. That is something, the only way to make data protection laws really effective, having people understanding the rights and businesses understanding their obligations. Now let's, speaking about businesses understanding obligation and people understanding the rights and capacity building, no one probably better than Renato Leite, who has been spearheading data protection capacity building initiatives in Brazil since years, and now also works for Twitter, implementing those very important concepts into business practices, is today with us. So Renato, thank you very much for being with us. Please, the floor is yours.
Thank you, Luca. Thank you for the invitation. Thank you, and congrats on organizing CPDP and this panel. It's really, really good to be among friends. That's what we have the chance to say, to be, and sorry because I was late. I guess Data Privacy Week, you get to divide yourself in a different, in a series of panels. So I'll get a little bit, so as Luca mentioned here, currently I wear 2 hats. So the first hat that Hannah mentioned, I am one of the directors of Data Privacy Brazil. So Data Privacy Brazil, it's an association which aims on providing education, training, capacity building on privacy and data protection, and also research and other activities which in some way are supported by external organizations such as what Hannah mentioned. And one of the works we have, so therefore we have the school Data Privacy Brazil, education, and we have the association Data Privacy Brazil, which is NGO, a research NGO that has recently produced, we just published this week, the material about technical authoritarianism, was something that Hannah mentioned over here, and where we got the conclusion when we take a look of what happened in 2020, mostly in Brazil, getting to this particular work, the conclusion of this research was that the states increase its capacity to informational capacity to collect data, to collect information about the citizens, and this growth of this capacity was not accompanied by safeguards and measures to protect the society, to protect individuals. So I invite everyone here to take a look at these materials. So dataprivacy.com.br, where you can have access to this material. The other one is also the school, where it provides some education on that. And also, as Luca mentioned, I've been leading the efforts of Twitter on privacy data protection for LatAm. And one of the challenges that we had in 2020 was to make the company compliant with LGPD, which all of us know it's not an easy effort. And what we the aim that we have on 2021 is to find ways to cooperate along Latin America, and it very much goes along of what we want to discuss, what we are discussing in our panel. And getting a little bit of what I had the opportunity to coordinate in 2020 and what we are starting to do in 2020, I have highlighted 4 issues mostly from the practical point of view that we're going to have to address. And I know that we had Miriam here from ANPD before, probably she mentioned some of these things, but these were some of the issues that we have to follow on according to what we did in 2020. So the first one will be how companies in Brazil will deal with international data transfer. So right when I joined this panel, we're talking about what Argentina did in order to allow international data transfer together with Uruguay. This is something that we're gonna have to do in Brazil. And I hope that we do it in a very short time. So right now, all of the companies in Brazil, all of the organizations in Brazil, if we take a look at the letter of the law and how they transfer data internationally, they are not in compliance with the regulation. We do not have, as we mentioned, getting for notes what we have in Argentina. Our law talks about extended clauses, binding corporate rules, ad hoc adequacy decision, and we need the work of ANPD, and the ANPD has to work with civil society, with academia, with the industry, with the private sector, also with the public sector to discuss those issues. So right now, what companies have is to rely on best practice, is to rely on what they normally do to transfer data internationally. Some of them, they have been relying on SCC, extended contractual clauses that are even them, they are not as adequate according to the recent guidelines of the European Data Protection Board and so on. So taking that, those are the best practices they are implying here from an accountability point of view, expecting if they are in the near future, there is any consultation, there is any request from the authorities for the organizations to explain how they have been granting and guaranteeing individuals' rights in international data transfers. They said, okay, this is what we are doing. The second area that I want to highlight here, this is also going to be a challenge, is data subjects' rights. So if we get to compare LGPD with GDPR, LGPD, for my interpretation, has a wider set of data subject rights, not only from an individual point of view, from a collective point of view. What we're gonna see, and it goes a lot with what Hannah mentioned here, we're gonna see in 2021 a lot of associations, consumer associations, NGOs, and also other authorities, not only ANPD but consumer authorities, to defend those rights in a collective way. But in order to properly defend those rights, to grant those rights to individuals, we need some interpretation, we need some guidelines from the National Data Protection Authority. So what is the scope of some of the rights, how wide they are, what are the limitations, how we're gonna balance those rights with some of the interests that we're gonna have from public organizations, how those rights can be properly implemented on a corporate governance, privacy and data protection governance program. So can we just get the same structure that was built for other regulations around the world, such as GDPR, and translate it to Brazil, or we needed to adapt? So that's the other things such as portability rights, opposition rights, rights that we need a proper interpretation. And I know that Danilo is a really, really strong voice on this right to review of automated decisions, what it means or what it does not mean, that it can be reviewed by another algorithm, or it needs some human intervention or a human in the loop. And what would be a type of human in the loop that would be acceptable and would be not a violation of the regulation as the way it is interpreted right now. The third point that I want to highlight here is the question of DPO requirements along with what would be the requirements for small and medium enterprises. So the way that we read LGPD right now, it is applied in the same way, regardless of the type of company, the type of organization, the size, the type of data, and so on. We have provisions in the law that request further regulation by the National Data Protection Authority, such as requirements for the data protection, also known as encarregado in our law, and other obligations that maybe can be that do not need to be mandatory for startups, for disruptive and small and medium enterprises. So there is a lot of still for small companies, it can be a burden and also a very costly burden to comply with the regulation, even though the compliance project and efforts can be deemed as a way to innovate, a way to provide legal certainty. But in the end of the day, they need to choose what they're going to invest on. So if we have further guidelines, okay. So if we have further guidelines from the Data Protection Authority, it would be very good. And just the last point that I would highlight here, and is data breach requirements, and how is going to be the role of the authorities to investigate some of the breaches that we have been having right now, and some of the mass data collection activities that we have right now. So we saw recently data breaches from states, from the public sector, from the private sector. We saw some databases, and I probably have mentioned this before. Danilo probably have mentioned this about how the current government has developed some capacity to collect even more data about individuals, and what would be the role of authorities to tackle those issues. So these are the 4 points that I want to highlight, and I want to see them to be further discussion in 2021. And I thank you for your time. Thank you, Luca.
Thank you very much, Renato, for this. And indeed, the ANPD, the new Brazilian Data Protection Authority, really needs to tackle urgently these issues you mentioned: data transfers, data DPO obligations, data portability. They are only the most urgent of the extremely long list of norms and obligations and rights that are included in the new law but not specified, and so not enforceable, not enjoyable, or at least not easily, and not without creating a lot of confusion and legal uncertainty at this moment. Now, before moving to the open debate part, I would like to ask to Katiza Rodriguez, who has been leading privacy discussions in LatAm and globally over the past for almost 20 years. So no one better than you, Katiza, can provide a feedback and an overview of and reply to the various points that we have been highlighting over this discussion. Please go ahead, Katiza.
Thank you so much, Lucas. Thank you, everyone, the CPDP, the technical team, and everyone for the kind invitation and for guiding us to participate today in the meeting. I would like to make a few overviews and a few opportunities that I'm seeing right now in the region. As we already know in this panel, data protection laws are no longer a European phenomenon. Just recently, since the adoption of the GDPR, we have laws in Brazil, but also Barbados in 2019 and Panama also in 2019. Yet we can see that these new laws, these new trends, having inspired by the adoption of the GDPR in 2018. Just to give a few examples, both Brazil, Barbados, and Panama are inspired in the GDPR or in the directives in the case of Panama. Barbados is pretty similar law to the Brazilian law. And I will highlight just a few things that I think it's important for lack of time. From the comparison of these three laws, we can see, for instance, like Brazil and Panama includes a comprehensive definition of personal data, information that can identify or identifiable a person. The definition of personal data in Barbados, however, has certain limitations. It only protects data related to an individual who can be identified from that data or from that data together with other information in the possession of the data controller. There is another right that also came from the GDPR, like the right to portability. The free countries have that, with some difference between them. What is important is that sometimes these laws let the data protection authority determine the standards how, for instance, this right will be implemented. This is in the case for Brazil. So the role of the data protection authority in setting the standards and what it means will depend on how will be deferred to the authority. That's why, from a civil society perspective, having an independent authority is really crucial. Another right that already was mentioned by Renato is the right to be subject to automated decision making. We see that also in Barbados, also in Panama and Brazil. But the second point I want to make sure that even though we have this strength in the region, when it comes to data protection in the law enforcement context, a few countries have followed what is the European Police Directive, the data protection in the context of the law enforcement, the police. Argentina and Chile have some applied to the law enforcement agency, and Mexico have some data protection regulation for the public sector. Peru and Panama exclude law enforcement agency from the scope. Brazil creates an exception to personal data for public safety, national security, and criminal investigations, but it will lay down, and it's like very good, that they will have a specific legislation to approve to regulate these activities in the law enforcement. And so Colombia, for instance, the law applies to the public sector, but has exceptions like national security, anti-money laundering, intelligence. But the Constitutional Court has stated that these exceptions are not absolute exclusion from the law, but an exception to some provisions, and that complementary statutory law should regulate them, including be subject to the proportionality principles. So this brings me to my almost 4. I have 5 points to make. In the 4 is that there is an opportunity now on this intersection into law enforcement and data protection. It's an opportunity for civil society to try to, especially countries who will want to get an adequacy standard with the EU, to also try to improve the laws for government access to data. The European Court of Justice has noted the adequacy means essential equivalence, and there are a whole analysis of what these essential guarantees mean and how that these essential guarantees, which doesn't have to be exactly as the EU, but has to be based on international standards, international treaties, has to be found when the EU will be assessing fair countries' laws. So this is, the law has to be clear, precise, it has to be necessary and proportionate, and restricted access to data, or access to data on a generalized basis, which is a language that uses the court. It's compromise the essence of the right to private life. So any law that provides unrestricted access to data to governments will either be necessary and proportionate and will be against what the essential guarantees are put forward. There also requires independent oversight mechanisms. So good opportunity to check your oversight mechanisms in for intelligence agencies. And there are also effective remedies to be available, when they will assessing these laws. So I see this is a unique opportunity to try to bring international human rights law standards at the intersection of data protection, an opportunity that in the past, those issues were managed separately. My final point, I will say, that is not only about the EU assessing our country's law, but there is a trend about mutual recognition when Brazil, maybe, or other countries like in Japan, have to assess also European law. And this is an opportunity to see how these essential guarantees will apply to the EU. I'm saying this because while EU framework might be solid in terms of the court cases and the charter, when it comes to actually the laws by EU member states like Poland or Hungary might not necessarily all the time comply with these essential guarantees. So there is an opportunity also for Latin Americans when they are assessing the adequacy standard, the essential guarantees with the European Union, to see how that will work, how that the letter or the discrepancy between the EU as a whole and individual countries like Poland or Hungary, for instance. Finally, this is all the points I want to make, my 5 points, and I'm open for discussions. Thank you.
Thank you very much, Katiza. And as we have started with 5 minutes of delay due to technical issues, I hope the technical team will be so kind to give us a couple of final minutes just to wrap up and to have. Actually, we have a question for the panelists about if they consider. I would like to have a very concise, sharp reply by each of you. If you consider, we have only 2 minutes. If you consider that within the current COVID-19 crisis in the region, DPAs are prioritizing data protection, and data protection is something that's been prioritized in the context of COVID-19, or do you feel that this has not been considered a priority? This is a question from Christos, and it's for you all. We can start with Danilo, maybe, and then we can have a very quick round with Danilo, Hannah, Pablo, Renato, and Katiza, so that we can then wrap up and finish.
Okay, Luca, very briefly. Hello, Christos. I'm happy to have your questions regarding COVID and the questions regarding user personal data in COVID. It's very important that this issue came at the same time Brazil began discussing and implementing its data protection law, because maybe in our case, we are in a very particular situation where the need to protect data is discussed together with the need to use personal data, and both for very strong reasons, for public interest, for protecting people's rights, fundamental rights indeed. And I wonder if the outcome of this discussion, together with several other particular facts, such as the creation of the PA and the fact that there is a huge public debate. We are in the middle of debate, so we believe it's huge. Of course, there are many more critical situations, discussions in Brazil, but we never saw a moment in Brazilians' public debate where data protection was so key to several discussions. That's for sure. And I believe it will be very important to be attentive to the outcome of the discussion, because it may come out something a bit peculiar, different, tying together the use of personal data together with need to protect, something that was in many prior draftings a bit formal and not so pragmatic. That's a very pragmatic discussion. I believe it's very important to focus on, and I see we're short of time. I give back to floor to Luca.
Luca, no posso te ouvir.
I'm not sure I will have time for everyone to reply, because I'm receiving orders from the technical staff to wrap up as fast as possible. So if anyone wants to provide a very concise last remark, this is the moment. But we will only have 2 more minutes, and consider it that we will have to speak for only 30 seconds if we want to finalize. Please.
We're done.
But we still.